Shutdown is over, everybody, so to those of us who don't work for the government, I'm afraid our favorite morning cocktail lounges are about to go back to being empty and sad. Happy Friday, everybody. I'm Brino, and this is the Aloha Friday Morning Report on the federal courts for November 14th, 2025. Please double tap your screen, comment your favorite secret morning cocktail lounge, or whatever that means for you, and stick around through the intro. It gets me to the FYP faster. Grab yourself a stylin' morning report coffee mug and a coffee colada, or consider subscribing here or to the stacks. And let's end this week right. Normally Friday is just laid back and silly, but I got some thinkers here today. I think you might find them interesting. And my fourth one today is spicy. All right, so I'm going to start out with a case that sort of went under the radar this week. That is Veneno v. U.S. It was just a petition to the Supreme Court that got rejected, but there's an impassioned dissent written by Justice Gorsuch and joined by Justice Thomas, and it's worth paying attention to because it's a really good example of Gorsuch's big soft spot, and he always sort of stands by this. That is the right of Native Americans. Justice Gorsuch is incredibly protective of the right of Native groups. It's like his number one thing. He grew up in Colorado. I don't know if that factors in, but it is his issue. And Veneno v. U.S. was asking the court to consider overturning an 1886 case called U.S. v. Kagama. According to Justice Gorsuch, quote, Kagama helped usher into our case law the theory that the federal government enjoys plenary power over the internal affairs of Native American tribes, which Gorsuch strongly opposes. Now, a lot of our old decisions related to sovereign authorities within the U.S., particularly ancient pre-American cultures that are still operating here, tend to take one of two stances. Either A, we won, and our government controls. Suck it. Which is what this case is. Or, those simple tan folks can't possibly understand our complex American ways, so we're better off just leaving them alone to bang their little drums or do whatever it is they do. And I'm not actually joking. As an assistant AG in American Samoa, I spent a lot of time reading what are called the insular cases. Insular meaning island. And they're basically about how these simple island people are better off being left alone because they can never truly understand our complex American exceptionalism. And that's basically why to this day, American Samoans are born as U.S. nationals and not U.S. citizens. And no one knows what that means. So Justice Gorsuch hates these cases. He's been talking about overturning the insular cases for years. This is an opportunity to overturn Kagama, which is equally insulting and he believes oversteps tribal authority. And the fact that the court voted not to hear this case really ticked him off. He is not happy. The bunny slippers are off. But I wanted to make you aware of it. First, kind of broadly, it's worth understanding that these justices are human beings. Each of them have strong opinions about something that might not line up with the rest of their ideology and is worth keeping an eye on. But second, more importantly, in Gorsuch's case, this is his big deal and you should know that. There are administration policies right now that may impact tribal rights, birthright citizenship, border crossings, tariffs, voting rights. And if these cases are brought in the right way and frame those issues in a way that challenge his firmly held belief on this, he might give us a totally unexpected opinion. You never know. So keep an eye on this. Keep this in the back of your head. Okay, now we're going to check in on California v. Department of Education, which is a case about the administration canceling and clawing back grants from DOE that included efforts to promote recruitment and hiring of teachers in hard-to-staff localities and subject areas, aka DEI. But for the last couple months, the courts have been trying to sort out how they're going to approach these weird clawbacks that the administration keeps trying to do with these grants. Different courts have taken different approaches. Nobody really seems sure how to deal with this. Because on the one hand, the administration has taken a bunch of these promised grants and cut them off. So they've stopped sending money. So this is a question about money, right? Okay. But on the other hand, the administration's reason for cutting off these grants is usually a philosophical disagreement with where the grants are going. And that sounds more like some sort of a constitutional question, or maybe suppression of someone's opinion, or an APA problem, which I won't get into right now because it's Friday. I'm not going to punish you. But the Trump DOJ has been arguing that since this is primarily about money, these cases, which are currently in district court, should all have to be refiled in the Court of Federal Claims, who handles contract and money disputes. Reason that's a problem is that everybody except for the Trump administration is worried about how much they're spending on all this litigation. So having to file their cases all over again in a new court, probably not possible for some of these guys, and the Trump administration knows that. But what's the answer? Are these cases about money? Are they cases about free expression or the government repression of ideas? Well, this judge in Massachusetts has kind of split the baby, and so as usual, nobody's going to be happy with this. Nobody ever likes a compromise. So yesterday, Judge Kelly decided that the answer is this is a case about both. Part of this case is about getting money, and part of this case is about whether the reasons violated the Constitution or whatever. So the judge has dismissed not the whole case, but just the part about the money. And the judge said, we're going to have a whole trial about whether the government was or was not allowed to cancel the grants for the reasons that it did. And then, if my decision is that no, government was not allowed to do that, then you take that decision over to the Court of Federal Claims and get that paper. All right? Now, I am not sure if this was the right decision or not, but it's an approach. And I don't think California is running out of litigation money anytime soon anyway. Fed's probably going to go broke first. Besides, having a completely clean case that only says the administration can't cancel grants because of an opinion may be useful in some other cases. Who knows? All right. We got an answer in the motion to dismiss criminal charges against Congresswoman McIver from New Jersey for an altercation at an ICE facility back in the spring. So, quick background. Members of Congress inherited a constitutional immunity all the way from English Parliament that protects them from any kind of civil or criminal liability for anything that happens during speech and debate on the floor of Congress. It's called the Speech and Debate Clause. But in 1805, if you were a Maryland congressman and you wanted to do something illegal, you could just ride your horse an hour or so to the Capitol and do whatever you wanted. A New Hampshire congressman had a bit more of a trek. So to make things a little bit more fair, that immunity was extended to your trip to and from Congress, no matter how long your trip was. And that trip can get really long sometimes. Well, Congresswoman McIver got arrested at an ICE facility in New Jersey. On the one hand, she was definitely not traveling to or from Congress. On the other hand, she wasn't there for her health either. This was part of her job as a congressman, right? Congresswoman. So where does this immunity end? Well, there are 3 charges against her, and she filed a motion to dismiss them all because she was immune from the charges under the Speech and Debate Clause. And generally the judge held, this was not part of her journey to or from work. It doesn't serve a legislative purpose, so the fight she got into with ICE agents is not covered by her immunity on 2 of the counts. But on one of the counts, the judge wasn't so sure, because the judge took a look at the video from the ICE facility, and the Congresswoman was trying to get in. And on the video, an ICE agent blocked her path. And that led to 1 of the 3 indictments. And the judge said, you know what? At that moment, she may have been trying to get into a federal facility as a member of Congress to take a look at it, and she's allowed to perform oversight. That dude stopped her. And at that moment, she may have been blocked from performing her legislative duties. And if that's the case, then her response to being blocked might be covered by her speech and debate immunity. Now, the judge didn't rule on that 1 count. He dismissed the other 2 and said he wants to reserve that 3rd one for later. But it's an interesting example of how really old con law that's rooted in even older parliamentary law can get put into action even today. So it's fun to watch. Okay, last one. And when I read this, I was like, ooh. Okay, we're going to look at U.S. v. Comey, also the Letitia James case, because the situations are kind of linked. So, quick recap. Interim U.S. Attorney for the Eastern District of Virginia, Lindsay Halligan, may not have been properly appointed. The traditional reading of the law is that until the Senate confirms somebody for this job, the president can appoint somebody, but after 180 days, the federal judges in that district either get to decide to keep that person until someone's confirmed, or they choose someone else. But the Trump administration just keeps firing whomever the judges choose and reappointing a new person or the same person for another 180 days. And they've done this in New Jersey, Nevada, Los Angeles, and the courts are now deciding whether the people can stay in their jobs, but more importantly, whether the criminal charges they brought while they were in their jobs can stick. Now, in most cases, like New Jersey, they've allowed the charges to stick because the signature line down at the bottom will have multiple lawyers' names on it. So even if one gets removed, there are others. Okay, that's kind of key. That signature at the end of every legal document is actually a really big deal. We have something in the law called Rule 11. It's not always called that, it's just what I call it. It's a federal civil rule, but versions of it are everywhere. States, criminal law, it's sort of all over the place. All it really says is that filings have to be signed by a lawyer. But the thing is, you can get disbarred under Rule 11 if your name is the one on the signature line and the filing is somehow unethical. So the signature line is a really big deal. You're sort of affirming your license there, putting your bar admission on the line when you submit that document. And unlike the cases in New Jersey, when Lindsay Halligan brought these cases in Virginia against James Comey and Letitia James, no other lawyers would sign it because they were both. So the first question is, if Halligan had no authority as prosecutor to sign on that line, and she's the only one who signed, then are both of these indictments, Comey and Tish James, void? But we have a twist, because Pam Bondi, the Attorney General, says she got a copy of the grand jury presentation, the transcript, and read what Lindsay Halligan said to the grand jury, thought it was great, thought it was perfect, and then she signed on the line, added her signature, and she is definitely confirmed. So, question 2. If Pam Bondi ratified the indictment after the fact, is that enough to unvoid it? Okay, we got those 2 questions. Well, yesterday there was a hearing about all this. This is where things get juicy, because the judge ordered the DOJ to turn over a copy of that grand jury testimony so she could look at it herself. Funny thing is, when it arrived, it was incomplete. In fact, it was missing most of the stuff that Lindsay Halligan had said on the record, especially the stuff near the end as she was making her case, which is pretty crucial. And the judge said, did you guys just cut out the parts that I'd need to see so I couldn't see them? And the DOJ lawyers were like, no, of course not. We are so sorry. This is just the only copy of the transcript that we have in the file. Wait for it. Let that sink in. So I'm going to quote the judge here from the hearing yesterday. It became obvious to me that the Attorney General, Pam Bondi, could not have reviewed those portions of the grand jury presentation by Ms. Halligan. How does the Attorney General ratify and say she reviewed the grand jury transcripts when they did not exist in the Justice Department records at the time? So one more time here, guys. Pam Bondi says she read the grand jury transcripts, read the part where Lindsay Halligan talked to the jury, and signed off on the indictments herself, finding them to be sufficient. But Pam Bondi never had a copy of the grand jury transcripts with the parts where Lindsay Halligan talked to the jury. So, this is going to get interesting. Oh, and one more thing. Last year, when Jack Smith indicted Donald Trump, Judge Eileen Cannon, remember her, dismissed the case because she said Jack Smith was improperly appointed. Why? Because he'd never been confirmed by the Senate. And so she dismissed the charges against Donald Trump. And this judge yesterday asked, if that's true, if that argument was made by your lawyers who are now working high up at the DOJ, then how does Lindsay Halligan, who also was never confirmed by the Senate, bring charges against James Comey and Letitia James? So somebody's going to get in trouble here, guys. We're going to have to wait and see who, but it sure is interesting that Pam Bondi's husband tried so hard to get on the board of the DC bar, who decides whether or not attorneys lose their licenses. So, all right, folks, that is your Aloha Friday morning report. Check out my profile links for ways to support my work if you like what I do. Mahalo to Fagenge, Karen, Sarah, Susan, and Ryan for hitting my Venmo. I really appreciate it. Fa'afetai for watching, everybody. Manuia leaso. Have a great weekend.